Welcome back. We're joined now by Adetokunbo Momuni, Executive Director of SERAP. Thank you for coming on today.
Thanks for having me.
Well, some of those cases that they've lost, yes, they've won a lot of cases. The government, but under the agency, different agencies of government, the AGF, the AFCC, the ICPC, all of them. But these ones that seem not to have gone their way is huge because if you look at the attention it generated while the arrest was made, the kind of persons that were involved in those cases gives it all the more attention. But when these cases fell through in the courts, many just have big question marks about it. You read some excerpts of the media for those who covered that particular ruling. What was some conclusion when you heard them?
Let me just say immediately that under the Nigerian legal framework, every litigant, including the government, the prosecution, has a right to take its matter to the highest level. Let me remind viewers of the struggle of Chief Gani Fahimi. When Delegwa was murdered, Gani Fahimi sought to exercise the power of a private prosecutor. Asked the Lagos state government, I have sufficient evidence. These are the people that I suspect must have committed this crime. He went to the High Court, lost. He went to the Court of Appeal, lost. He was at the Supreme Court. The Supreme Court eventually guaranteed his rights that if the Lagos state government there will not prosecute those people, then Gani should be given the fiat as a private prosecutor to prosecute. So the journey to justice on both sides is not a one-way traffic, is not a dash, it's a marathon. It will have been convenient to say the government is losing if after the various pronouncements that we have just had in these very recent days, and the government kept quiet and says nothing will happen, we are not appealing. So one will finally conclude that seriously there is problem if at the end of the chain, onto the Supreme Court said these judges have no case to answer.
No, why would one conclude that there's a problem if prosecution doesn't do a good job?
No, you are prejudging the matter.
No, I'm just assuming. Without considering that that's the case. Because you said that there will be a problem if, at the end of the day, the Supreme Court says no case submission.
Now, what I'm saying is that let us put this thing in context. It is not as if, and I don't think the government wants that. The government does not want a rubber stamp judiciary. First, crime has to be properly investigated. It is investigation that will lead to effective prosecution. Witnesses must be up and doing, and they must give their best in favor of this. Because, get it straight, if you are in a criminal prosecution, whatever happens, the judge is not supposed to be on anybody's side. The judge is supposed to analyze facts and evidence and come to a just conclusion. That is the oath the judge has taken.
Do you think that the prosecution was perhaps too hasty in trying to see that these cases are prosecuted as quickly as possible? Because the guest, Senior Advocate of Nigeria, Ngige, who was just in the studio, said that they were under pressure to deliver, considering the high-profile nature of those cases.
You see, the question of being under pressure to deliver will not arise in a matter of justice. Justice rushed is no justice. So also is justice delayed, is justice denied. So it is the prosecutor that should weigh the evidence that it has against any person accused of a criminal offense and decide on what to do. The question of being boxed into prosecuting in haste should not arise. That is my sincere opinion.
But you know, given the media hype that was generated, the public at least thought that they have a crack case thorough investigation has been done. You have them by the balls. The least they expected was to get to the court and see a no case submission in an 18-count charge.
You see, let me tell you about these voluminous count charges. I don't believe in it. When you have too many count charges, I believe that you are trying to second guess if this one does not sail through, this one will sail through. That is not, to me, effective way of prosecuting a criminal matter. So
does that suggest that that's what the agency, the prosecution was trying to do?
I'm not making a suggestion, but
no, because if you look at it,
180 count charges.
Yeah, but if you look at it, they say on the vehicle found with the son, how did it affect any case that was going on? No link. On the monies found in the wife's account, whether or not you could find any link to any case going on, no link. On whether or not they had, they even added, remember that, I think, what do they call it, a warrant or permission to have firearms. Eventually they said yes, they tendered it. And you thought that, look, some of these things don't look tidy.
My position is that when counts gets too many, you are trying to confuse a lot of issues. I am used to seeing very minimum number of counts, well investigated, that will lead to conviction.
Perhaps the prosecution was after the wrong fish in the pond.
I don't know.
Do you agree with those who suggest that it looks as if they wanted to just get something against them by all means? Just bring in as much as you can and see which one works.
No. Let me go specifically to the case of judges. I don't believe that it is an attempt to get just anything against them. For example, I'm a believer in saying, what would a judge be having voluminous amount of foreign currency in your house? You understand? So I don't believe that it's an attempt to look for just anything. But I believe that too many count charges spoil the broth.